Today, I want to talk about non-molestation orders. I'll be honest, it's a bit of a mixed bag. You'll be able to see the contrast in people's experiences of it. So first off, I want to look at what is a non-molestation order and how does it impact family court. It could be that you are looking at applying for a non-molestation order against your ex, or you could be on the receiving end of an application for a non-molestation order against you. So I'm going to try and look at it from both sides. Experiences range massively. I work with people who seemingly look like they've got so much evidence to obtain one and it's not granted, to people that have been on the receiving end of one. Then what they're telling me is that there's no evidence whatsoever for that to been granted. That's just a bit of a warning, really, is that there doesn't seem to be any consistency in terms of court across the UK. So if you are on the receiving end of a non-molestation order, you've kind of got three options. First one is obviously to accept it. Now, not many of you are going to do that, especially when you feel that it's unfair, it's part of a bigger pattern, it's all designed to cut you out. At that point, you can do what they call an undertaking. And this is where you essentially say, I'm not agreeing that I've done any of those things, but I am willing to do X, Y, and Z. Because ultimately, you don't necessarily want contact with your ex either, but you do want to be able to talk about the children or have contact to the children. So an undertaking can be sort of a softer approach. I have known some people then use that as saying, well, it's proof of you being guilty, but it's not. It is very different. It's an agreement that you enter into just to basically make things as easy as possible. I would get legal advice on which is your best process to go down. Obviously, the third one is to deny and refute and to present your own evidence of why this is an unfair application. And then you've just got to send in your evidence or go before the courts or the magistrates to say what your evidence is and why they don't need a non-molestation or it shouldn't be granted. So obviously, if one is granted, it could potentially impact your contact with the children, depending on the terms of the order. Now, some orders are for the adults only, but if the children are residing with them, there might be an element where they include the children in it as well. Again, that depends upon the order that is granted. Obviously, if the children are included in a non-molestation order, then that is going to massively impact your ability to see them and to pick them up and to go anywhere within their home. So you can drop off presents, for example, if the non-mol was about being around the house. So make sure you really understand the terms of the non-molestation order before you think, oh, it only covers them, and turn up at the house because you're there to see the kids. Actually, you need to make sure, are the kids included? Where can I go? Try not to sail too close to the wind either. I know it can be quite tempting if you think that it only covers X, Y, and Z to do W, but actually W might be a little bit too close. Then they might take you back to court and say you breached it, which technically you might not have done, but you might come across as being a bit of a dick for doing it. Whether you agree with the non-molestation order or not, you've got to be mindful of the narrative that was put in place to get it and don't play into that narrative. Obviously, if it is granted, then it can be used going forward. So it's almost like a big tick and that, oh, they must have done something wrong because there's a non-molestation order against them. And in the echo chamber that is family court could almost become the foundation for your case that there is this order and therefore you are abusive. It's been already found against you without actually going through any of the tests that family court goes through. Although it has been granted, it hasn't gone through the family court process, which could, if you got to a fact find, look at it again and go, well, actually, that was unfairly granted and it was part of a pattern. If you apply for a non-molestation order and it's not granted, your ex could use it against you as being part of this pattern of false allegations. So if you are going to apply for a non-molestation order, please make sure you've got the evidence to prove it. What I found quite strange is this disparity between what some people get it granted for and what some people don't get it granted for. And I think some courts look at them and then what's the impact of this going to be on the rest of their life? For example, and I have seen this in cases, the police are less likely to issue a non-molestation order against a police officer, a teacher, someone in a position of that kind of authority, because they know that it's going to have a huge impact on their career. They could potentially lose their job as a result of that being granted. And so they don't issue it almost to protect the rest of their life. I'm not saying I agree with that. It's just something that I think happens, and I don't have proof of it. It seems like an explanation as to why some of these things don't get through when actually there's a lot of evidence. So again, just be mindful that they are going to consider the repercussions on the whole life, not necessarily just your life. It does depend on your evidence as well, the quality of your evidence as to whether or not you get one. You feeling harassed because you know the person and you know the subtle ways that they do that is different to having a lot of evidence of unwanted text messages, for example, or unwanted phone calls. So it's important that you are able to separate out objective from subjective evidence. The objective evidence is the most powerful because they, they can't deny the existence of that. Whereas you saying they're making you feel uncomfortable is less likely. Again, not impossible, but it's less likely. Now, the basic principles, as far as I'm aware, again, I'm not a police officer, I'm not a lawyer, but it's unwanted attention, unwanted contact, and excessive communication. If you've engaged with them, then that undermines some of that. Ultimately, what you want to show is, despite you saying, please do not contact me about this, they keep coming at you. That is harassment. You going back and forth and going, look, please stop. That's not harassment because you're engaging in it. If you're feeling harassed, don't engage. Stop telling them or send one brief message saying, we've said enough about this. Please do not contact me about this anymore. There are issues around some of that, as in third party harassment. So they might then go to the solicitor and get a solicitor to keep sending you messages. They might get the kids to keep asking you about something. They might get the school to. But it's just being mindful of the broad parameters around a non-molestation order and what can maybe prevent you from getting one. They also will consider the impact on their human rights and their right to a private life, for example. So they don't want to overly restrict someone's movement because that's against their human rights and their rights to freedom. Obviously, whilst trying to protect you. So be mindful of what you're asking for if it's about a location, for example. Also, if there are children's proceedings going on, they might not want to include the children because that hasn't been resolved in court yet. Get legal advice, but make sure, first and foremost, that you've got evidence that this is harassment. On the flip side of that, why can it be so easy? And ultimately, it's because it fits into that same category as false allegation, which is where they're very emotionally seductive. And everything I said about feeling fearful can sometimes win judges over. So they can go in with very limited evidence and just sort of, again, I've worked on a case where someone spoke to the school about the kids. And that parent felt that they were being attacked by that conversation. So put that in the non-molestation order. That's a feeling. And sometimes, like I say, if a judge is seduced and buys into the emotional chaos that these people bring, then it could get granted on those grounds. Those are the ones that I would be sort of arguing against for sure, because it does lack the evidence that should be in place within the court process. But again, as you go through family court, you may be able to unpick it and say fact find, for example. So that moves us on to what can you do if you believe that one has been granted unfairly against you. Initially, obviously, you refute it and you present your evidence that says why you haven't been harassing them. That's step one. If your evidence, they say, doesn't prove that you haven't and that it is still granted, you can still unpick it through the family court process itself, but the non-molestation order will remain intact. Usually they're for a set period of time, so it would have to be reviewed on a set date. Obviously, bear that in mind. Don't suddenly, on the day that it expires, go against it. Be aware that there will be a review. It's about perception, how people perceive your behavior against the narrative that is being set, but it will come up for review. That's another point where you can present your evidence of how, one, it was granted unfairly because all of these things happen, but equally, you haven't done anything over that period of time, which shows that you probably aren't going to do it again. Most people, if they disrespect an order, then they'll have done it in that period. By following it, and you can evidence that you do adhere and that you've got no interest in going out, you've managed to not do that. Unfortunately, it can be used as this pattern against you, but equally, you can use it as a pattern of false allegations against the other person. So as you go into the process, you can start building up the fact that they lied to get a non-molestation order. They've lied about this. They've lied about that. By being able to show that from day one, they have been fabricating information and making false allegations, you can build up a much stronger case for the fact that this is what this person does. So therefore, take everything that they say with a pinch of salt. Again, none of this is easy, by the way. I'm just going through it on a fairly factual basis. So how does having one or not having one impact your contact with your children? Well, I suppose it's on multiple levels, really. The first one is it depends whether the children are included in the non-molestation order. If they are, then it could massively impact your contact. You may not be able to see them whilst that's in place. If it's about location, for example, or contact just with your ex, it may be that you can still have contact with your children, but you can't go to the house. So you can't drop off presents at the house. You can't pick them up from the house, but you can pick them up from school and you can get a relative to drop off presents or something like that. So again, it's about the terminology within the order itself. It can be used as part of evidence, which might then lead to contact stopping. So even if the children aren't included in the initial non-molestation order, the fact that one was granted could be used as proof that you were abusive, and therefore it could stop your contact while they investigate that, once you're in family court itself. On the other side, if you didn't obtain one or you didn't get the bits that you necessarily wanted, say around protection for the children, it can be used against you that you went to court and you got this false non-molestation order. That can impact your relationship with your child because the professionals might start to think that actually you are the problem. You have got this issue with your ex and it's not founded in any truth. It's a vindictive campaign that you are going on. It all comes back to the evidence. Make sure you've got the evidence to back up what you're saying has happened, not just your feelings. The third part of this is what messages it's sending to the children. It's all of a sudden you're not allowed anywhere near the house and someone's telling you constantly, well, no, they can't come to the house anymore, or they can't pick you up from there, or you can't see them anymore. And that's a really strong and powerful message that the children are being sent. Equally, on the other side of that, the children could get caught in the middle of this when there is this disparity between accounts. Like you feel unsafe and you wanted that protection in place. Whilst you don't have that protection, you feel fearful and you're constantly looking over your shoulder thinking, are they watching me? Are they following us? Are they going to take the children? That fear is going to be palpable and the children are going to pick up on that. The children are going to be impacted in lots of different ways. In this sort of situation, you're not sure whether to apply for one or you have got one. In Master Your Evidence, which is it's an independent course or it's free within our corporate toolkit, we can show you how to organise your evidence so that A, you can either refute it and show it as this pattern of false allegations, or you can present your strongest evidence to get a non-molestation order put in place at the start of proceedings. And the link to that will all be in the description. So take care, everyone, and speak soon.